Hi guys, welcome back to Simplify. In this video, we are going to cover an interesting topic on Indian Contract Act Part 4. Legality of object and consideration. Object refers to purpose of a contract. The object as well as the consideration must be legal for a contract to become legal. If its purpose is illegal by law, the contract may be void. For example, X promises to obtain for Y an employment in public service, and Y promises to pay rupees 1 lakh to X. This agreement is void as the consideration is unlawful. It includes unlawful agreement, agreements against public policy, and agreements, objects or consideration in partly unlawful. Moving on to void agreements. According to Section 23, every agreement of which the object or consideration is unlawful is void. Lawful objects and lawful consideration. The consideration of an agreement is lawful except in the following situations. It is forbidden by law. It would defeat the provisions of any law if permitted. It is fraudulent. It involves or implies injury to the other person or his property. The court regards it as immoral or against public policy. For example, A promises B a job in public service for which B promises to pay A INR 1000. This agreement is void because the consideration is unlawful. Agreements against public policy are void. Such agreements include the following: trading with an enemy, champerty and maintenance contracts, marriage brokerage agreements, agreements interfering with the administration of justice, agreements tending to create interest against duty, agreements regarding the sale of public offices, agreements intended to create monopoly, agreements in restraint of marriage, agreements in restraint of trade, and agreements in restraint of legal proceedings. Section 30. Agreements by way of wager are void. A wager is an agreement between two parties which entails that if a given uncertain event occurs, one party shall be liable to pay a certain sum to the other, and if the uncertain event does not occur, the other shall pay the sum to the first. For example, A and B enter an agreement to the effect that if it rains tomorrow, A will pay B rupees 100, and if it does not rain tomorrow, B will pay rupees 100 to A. This is a wagering agreement. What are not wagers or exceptions? Exceptions in favor of certain prizes for horse racing. Speculation does not necessarily involve a wagering contract unless it involves a common intention to pay differences only. An insurance contract is not a wager. Share market transactions with a clear intention of buying and selling stocks and shares is not a wager. Games of skill or athletic competitions and crosswords or literary competitions which involve the application of skills are not wagers. Essentials of a wagering agreement are: there must be a promise to pay money. Promise should be conditional. Uncertain event. Chance of gain or loss. No control over event. No intention to perform, and sole intention to gamble. Moving on to breach of contract. When one of the parties to the contract refuses to carry out his part of the promise, he is said to have breached the contract. The party who is injured by the breach of contract may bring an action for damages. Damages refer to monetary compensation for the loss suffered by the injured party. Remedies for breach of contract are: rescission of the contract, cancellation of all or some terms of the contract, suit for specific performance, actual performance of the promise is under contract, suit for injunction, order of the court directing to do or refrain from doing an act, suit for damages, and suit upon quantum merit, as much as merited for some service or delivery of goods without fixing any remuneration. Let's understand these remedies in more detail. Rescission. When one party breaches the contract, the other party can treat it as rescinded. In this case, the party is absolved of his obligation and entitled to compensation for damages suffered. Suit for damages. Damages are monetary compensation allowed for loss suffered by the aggrieved party due to breach of contract. Types of damages are: ordinary or compensatory damages, which arise out of ordinary course of events. Special damages are those resulting from breach of contract under special circumstances known to the parties at the time of making a contract. Vindictive or exemplary damages, which are given by the way of examples to others, and nominal or token damages, which involves awarding a sum of money when a party is able to prove breach of contract but has not suffered any real damage. Suit for specific performances. Specific performance means seeking an order from the court that the promise specified in the contract shall be carried out. When actual damages arising from breach are not measurable and monetary compensation is not an adequate remedy, then SP may be directed by the courts. Suit for quantum merit, Section 70. It implies as much as earned or as much as merited. If a party prevents the other party from completing his obligation under the contract, the aggrieved party may claim payment of quantum merit for the part of contract already performed by him. For example, a civil contractor who has commenced the work and later on has to stop the work because other party has breached the contract is entitled to receive the compensation on the principle of quantum merit.